doing Estoppel if it's necessary, but not forbearance. A second matter of courtesy, my learned junior, insofar as necessary, will deal with those issues.
Certainly.
Yes. So, always in matters of this nature, one comes to court very well prepared with submissions in a particular apple pie order, and then by the time you come to respond to the points that have been made, everything is ripped up and you have to deal with things on the hoof.
Yes.
I'm quite anxious to deal with a few things at the beginning of my submissions to address certain issues. There are, in fact, a number of short points I want to make. But before I just go into those short points, by way of preamble, can I just bring the court back to what this case is all about? It's about retained pay, which is the product of collective agreement. It goes back to 2007. Livingston is the same as everywhere else. I think we've established that. The fact that we focused on the Livingston pay and conditions deal, it makes no jot of difference what we're talking about. It's all over the UK, and in particular the English sites. And it is a form of pay protection which Tesco brought in, and we'll get to the significance of the representations in a moment, but it is clear beyond any doubt whatsoever the purpose of its introduction was to prevent the hemorrhaging of experienced warehouse staff right across their operation in several distribution centres at a critical, and I quote from one of those documents, a critical phase of its programme of expansion. Another few very basic facts. When the defendant's plan was first discovered in the middle of January last year, this affected no less than 367 people, 367 employees. I will literally shout out the page references for your note. It's page 116 of the supplementary bundle. Paragraph 4 of the judgment, it's recorded how staggeringly important this benefit was and is. Between 32 and 39% of the pay packets of each of the three individual claimants who joined USDAW on the papers as claimants. And thirdly, each...
Just to avoid any hyperbole there, I mean, I quite follow that's true of the particular claimants. It's not true of all 367.
It's not, but what I'm seeking to convey, my lord, is to the individual, the ordinary warehouse operative, taken across the piece, and these three were not selected because of the impact on their pay packets. We have people in that group for whom this is the most significant impact in terms of their overall remuneration.
Yes. Yeah.
So you have, my lords, what the central issues are in the case. We want to make a number of observations which we say are important when you are considering the structure of the appeal, which is essentially express term, implied term, injunction, declaration, and estoppel, should we get to that. This is not a typical case involving common terms of conditions on hours, salary and duties. We do not shrink away for a second from the fact, as recorded in the judgment of paragraph 42 on page 59. These are exceptional facts. The judge was understandably careful to have me confirm that, my lords, first time round. You've got it there in black and white. And that is relevant, for example, to any floodgates consideration or concern as to what it is the impact of this case. And we say that the judgment involves no extension to the law. We have got the substantial line of authority, and your lordship, Lord Justice Bean rightly anticipates I was going to say that the PHI cases, as they've been referred to, and they're not just PHI cases, we have a redundancy case, we have a strong succession of judges saying in the superior courts and at first instance in the High Court, this is what you do in this situation. So this is not a novelty. We're not trying to extend law or make new legal points. And we say that this judgment involves the application of well-established common law principles. We go further than that. We say, contrary to what has been submitted this morning, this case provides a paradigm example where the necessity to apply a term falls within what we all agree are the narrowly prescribed set of circumstances recognised in the case law for the implication of terms. So we say we confront that, we deal with it, we say we have no difficulty with it. Want to make these short preliminary points in the light of what's emerged this morning. The first is on the structure of the appeal. Could I ask the court please to go to page 14 of the core bundle, which we find there the grounds of appeal. Ground 2, paragraph 2. So this is where the defendant is descending into the particulars of ground 2. Sorry, page 14 of the core bundle, it's 2A, ground 2, 2A, where there are set out 5 separate particulars under ground 2, starting at 2A on page 14. Yes. So, first point is this. Look at 2A. The term which the judge found it necessary to imply was based on her misconstruction of the express terms. So that is a point which is parasitic on ground 1. 2B, still page 14. Nothing expressly stated there, but if you just digest the wording there, the officious bystander is referred to. But essentially, my submission is that the phrase I would use is that builds upon the defendant's arguments on ground 1. It's not overt or express in the way it is in A, but it builds upon, we say, that very ground. 2C is more clear and stark. The contracts would not lack practical coherence without the implied term, and it's the next part. The effect of the contract was that for as long as it subsisted, the right to retain pay would remain a feature of each individual's contract. That's a ground 1 point. So again, it's either parasitical upon or wholly connected with or contaminated by, depending on your viewpoint, ground 1. And number 4, I say, number letter E on page 15, I say that's another building upon point. So I invite your lordships, when taking an overall view of the appeal and the structure of it, bearing in mind that the defendant, in order to succeed in this case, has to show that the judge erred in law, and erred in law on the basis articulated in the grounds of appeal. I'm entitled to put that strict case to this court. We say everything stands or falls on ground 1. We also say, and I will say something in a moment about the injunction in the light of the exchanges that have been in the morning session. We also make a very straightforward point about the relief, the injunction and the declaration. I postulate it in this way. Once the judge had found for my clients in relation to the liability issues, what was she supposed to do? Putting it...
To not give a penal injunction, because normally you declare contract rights and then you sue for damages. So rhetorical questions are dangerous.
Well, I'll deal with it rather than it being rhetorical. I'll answer my own question. That would not afford a proper remedy to the claimants, because the claimants would be making the arguments that one would normally make in an application for injunction. Are damages an adequate remedy, balance of convenience, etc., etc.?
Well, that's only on an application for an interlocutory injunction.
Yes, well, certainly for an interlocutory injunction. Yeah. But the point rather is this. If they did not secure the injunction and they were left with the position of having to sue, either in the High Court or in the tribunal, their remedy would be nothing like what they would obtain if the court was right to uphold as an entitlement their right to retain pay. So scenario A, there's a declaration that this person is entitled to retain pay. That has the impact that we will discuss, no doubt, this afternoon. It was the subject of questioning this morning, but it's going to be substantial, come what may. Scenario B, the claim for damages or the claim in the employment tribunal. And certainly the claim in the employment tribunal is of no value realistically whatsoever. For a start, the claimants in the employment tribunal would have to win their cases. And one of the things that Tesco would say is that this was an SOSR, some other substantial reason dismissal, the mixed bag of potentially fair reasons for dismissal, because you can't actually pin down every circumstance. They would say it's a business reorganisation. Here's a good business reason for doing it. Here's the consultation. And look what happened. X%, and I shudder to think what the percentage was, but as the time was moving forward and people were going home and having conversations at the kitchen table about these offers of 18 months lump sum, when the alternative was oblivion in terms of the job, guess what? Dozens and dozens, if not hundreds, then signed up. They ended up that the cohort, who became the cohort for the purposes of this claim, was diminished substantially. So the employment tribunal is with respect to it, in terms of overall availability of remedy, not a particularly fruitful avenue. So I do say, once the judge had decided that we were right on any basis, that we were correct, I say that the fact that she gave the relief that she did is unimpeachable. And yet again, I say, has the defendant shown that she erred in law in relation to doing that? Because what is applicable to injunctive relief at the interim and the final stage is the use of equitable discretion. Once equitable discretion is in play, it is very difficult for that to be disturbed, lest it be shown that relevant factors were not taken into account or irrelevant factors were taken into account.
So unless I've missed it, and if I have, I apologise. One of the things she says at 55 that she took into account was the damages would not be an adequate remedy because they would be limited to the losses recoverable in any claim for unfair dismissal. And that seems to be wrong, I thought, because if the retained pay was worth 40,000 a year and you were deprived of that in breach of your contractual rights, then you go to court and say, I would have had 20 years of employment, I want 20,000 a year for 20 years, and you wouldn't be limited to the employment remedy. So she has made an error, hasn't she, or has she not?
Well, just excuse me a minute, I'll just catch up with you on page 63 and paragraph 55. Just allow me a moment, please.
Yeah.
No, she's not made an error. 2 points, she's not made an error. And secondly, if that is an error, it is an isolated error in relation to what is available as a remedy that does not affect the sustainability of the conclusion that the injunctive relief should be.
And it's not an error because?
Give me a moment.
It's not an error because? Why is it not an error?
Because, for example, Edwards and Chesterfield Royal Hospital, cited in our Skeleton 2012 case, Supreme Court, damages were not recoverable for breach of contract in relation to the manner of dismissal, even where the breach was of an express term of the contract's employment, regulating.
But Mr. Gilroy, aren't we putting the cart before the horse? I mean, the main point is whether the judge was right to find that it would be a breach of contract for Tesco to dismiss the claimants, even coupled with an offer of re-engagement. If the judge was wrong about that, then the question of remedy doesn't arise.
Yes.
If the judge was right about that, then the question of remedy arises. As to that, and either take it now or at the end of your argument, I'm not aware of any case in where an injunction has been, a final injunction has been granted to keep somebody in their job against the wishes of the employer, except cases concerned with procedure which should have been followed and hasn't been, in which case the injunction is against dismissal until and unless the procedure is carried out. Or 50 years ago, the case of Hill and Parsons involved Denning's Day. And I'm not aware of any other, but if there is any other, please tell me.
Yes, we're not putting before you a case where a final injunction was given in those circumstances. What we are saying is that this case falls foursquare within the Aspden and Genvy and Briscoe and Hill line of authority. Now, the fact that the final injunctions may not have followed in relation to those cases does not diminish the force of the argument that there is merit in the claims advanced by the claimants in those cases, which is mirrored by the merits of the argument by the claimants in this case, as accepted by the court at first instance in this appeal. And the fact that one cannot point to similar cases where different types of remedy or similar kinds of remedy were obtained does not diminish the force of the argument that if there is merit in the case, if the fact of the matter is that liability is made out, if the claimants are right on express and implied term, then one has to consider what is the appropriate remedy for that. And the court exercised its discretion in the claimant's favour. Now, I'm not seeking to duck that question, but I'm conscious that I want to address these things in a particular order. And Your Lordship will take me to task on that, no doubt, if I don't come back to this. But I just want to make these preliminary points because of certain things that were raised in the course of this morning's hearing.
If you're moving on, and I quite follow the sense of moving on, when you come back to injunction, I would like to be persuaded that it isn't possible just at common law to get damages. And you may want then to go to Edwards and Chesterfield, but don't go to it now.
Yes, thank you very much. Now, I want to focus on these short, discrete points of things that arose during the course of the hearing today. This point arose principally in the course of exchange with my Lord Justice Newey. And this was the question of the admissibility and relevance of the contemporaneous documents and the fact that it's trite law, that doesn't inform the construction issue. Simple answer to that. There is substantial case law, much of it actually quoted, or some of it quoted, in the judgment, that the test that one is applying is what meaning would the agreement convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the agreement. Now, I say that that person, the reasonable person having all the background knowledge, would have the knowledge of the material that we rely upon. So that's where I say, my lords, that's where that material fits into the case. It's not a question of using it to construe. If it satisfies a temporal test, which is the question of when was that material available, that goes back to the exchange there was this morning about, well, did it come out before the retained pay was agreed or after? The obvious significance being between the two different scenarios. That's a matter that we say, if you look carefully at those documents, these documents were done in advance. And I think my Lord Justice Bean actually picked that up with a few of these documents.
Just pursuing this a moment longer, I think Mr. Gar Robinson is right that there is an explanatory notes exception to what would be the ordinary rule. So possibly, as I think he was saying, the admissibility of the material would depend first on the timing point and second on whether these materials can be classed as explanatory notes.
Yes, and that's a fact-sensitive aspect in relation to which I simply proffer a gentle rejoinder to say, before one simply puts up a steel gate and says it's not relevant because it doesn't go to construction, I say be careful about that because of the reasonable person having all the background knowledge. Now, the references for that in the judgment, to be absolutely sure that our judge here in this case was mindful of that, is paragraph 21 at page 50. I just shout these numbers out for your reference. And a reference to the Anderson case. It's paragraph 38 on page 56. where Lord Hoffman in Chartbrook is quoted, and it's page 57 for paragraph 40, which again recites without citation the same formulation of words. So that's all I want to say on that.
I think you would have to be really careful about Chartbrook, because Chartbrook affirms the rule that you can't normally take into account things relating to subjective intent.
Well, it does, but what I'm relying upon as a rejoinder to that very point is the very passage that is quoted at paragraph 38 of the judgment at page 56 of your core bundle, where Lord Hoffman himself is quoted in Chartbrook, reciting that form of words that I've already used, the reasonable person. So yes, there are lots of different points made on different issues, but there's no getting away from it. That is a relevant consideration. That's why it is absolutely relevant for the claimants to have gone before this judge at first instance to point to those documents and the extreme way in which matters were expressed to get their agreement at this crucial time.
The explanatory notes point may well get you home, but just on what Lord Hoffman is talking about, if you go to the Investors' Compensation Scheme case, tab 15, bundle 2,
Yes.
and go in that to page 912, so this is behind tab 15, page 912.
Yes.
And at the bottom of the page, Lord Hoffman summarises the principles, and he says interpretation is the ascertainment of the
Yes.
meaning which the document would convey to a reasonable
Yes.
person, which is the bit you're relying on.
Yes.
And then he says, well, the background includes all sorts of things, but then he says in 3, the law excludes from the admissible background the previous negotiations of the parties and their declarations of subjective intent. So he specifically carves out this exception.
Yes, he does. But if it is being suggested that he carves it out in a way that excludes factor 1, I would respectfully disagree with that interpretation, because without ascribing a particular score to the weighting that's applied to those 5 factors, they're all factors to be borne in mind. These are all matters for your lordship's impression, and I dread to think the number of times you've had people standing in front of you citing that particular case. So you'll be extremely well versed in that. I want to deal with another point that came up this morning. The supposed conundrum of the employee who leaves. He goes away for 5 years or 10. He comes back and he says, hang on a minute. What about this briefing note when I used to work for you? It says that as long as I'm employed by you, I get retained pay. That doesn't work, and we haven't suggested it does. Do I need to pursue that any further, Milton?
Not so far as I
Not at all.
No. Well, that's fine. I will move on. The next point. We approach the case on the basis that the case of Malach represented a fundamental barrier to our case getting off the ground, because it was said Malach, reason for dismissal can be good, bad or indifferent, or even in fact non-existent. You don't get past Malach. Well, that's not the case, and we now have the concession from the defendant, and I'll give you the transcript reference for this. My learned friend at page 70, line 9 and subsequently, and page 71 at paragraph 12.
Wait a minute, let's find it.
70:9 from this today's transcript, my lord.
Oh, today's
Transcript.
Ah, right.
Sorry, today's transcript. Learned friend, having cited Malach in the skeleton argument, we're now told, and this is his quote on Aspen and other cases, the point in these cases is that where a party has, an employer has, provides for a contractual benefit of the provision of disability benefit or PHI insurance, in the event the employee is unable to work through sickness, the courts take that to mean that where the employee is unable to work for a long time through sickness, of course, other things being equal, dismissal will be likely on the question of on that very specific contractual protection against that very eventuality, and if then sought, if you qualify for the sickness benefit, you'll be paid the sickness benefit. The whole purpose of that provision is that you should be paid that benefit when you are unable to work. And that purpose is frustrated if it's possible to dismiss on the very ground that you're unable to work. This is exactly our situation. It's a different factual scenario, but there is no difference in the genre of the case, factually. It's a accruing right to benefit. He's either qualified for a sickness benefit or he's about to qualify. In those circumstances, as an implied term, preventing the employer to dismiss on the ground that he's unable to work. And this is an important part. It is a very rare case, and it's a very modest qualification to the generally unfettered right to terminate on notice. So let's just pause there for a second. It is agreed between the parties to this appeal that there is a qualification to the unfettered right to terminate on notice. So Malak does not hold the ring. It does not hold the day. So as a matter of principle, it is no answer to my case, having won at first instance, that you simply can't fetter the right to terminate on notice. Well, if we have that concession, where does the defendant go with its argument that the right to the implied term, as found by this judge at first instance, is irreconcilable with the right to terminate on notice? Because she has found on this particular factual matrix that there is no difficulty in conducting the very reconciliation exercise, I think she calls it, that Mr. Justice, I think it was in the Aston case, Mr. Justice Sedley conducted. So it was openly confronted. This apparent tension and conflict, it wasn't avoided, it wasn't ignored, it wasn't overlooked, it was openly confronted, dealt with, centre stage. There's the conflict, how do we resolve it? And learned friend, when he dealt with Aston and his submissions, he said, and this is reference 7112 in the transcript, again, it's a very rare case and it's a very modest qualification. The generally unfettered right to terminate on notice only applies to a few employees when the right is accrued or has accrued. It's a situation where there's an inconsistency of the contractual scheme in the express terms of the contract. Now, if I have enough time, I will go into some of the detail on the cases that I seek to rely upon. Maybe I'm going to be left with giving you page references and paragraph references to those judgments. But basically, that line of authority has been brushed off by the defendant. It was brushed off at first instance, and it's brushed off in this appeal. And it is not apt to be brushed off because we say, number one, having established that Malak does not hold the ring as an absolute bar, we say we're actually in agreement about the general principles. We say the only dispute here on this aspect of the case is whether this case, this factual scenario, is actually apt for the incorporation of the implied term of the type that was incorporated, or deemed to be implied rather, in the case of Aston. Next short point, taken against the judgment below, the judge did not consider alternative formulations of the implied term. That is a complaint that is made in this appeal. Well, we have an easy answer to that. The reason there was not an inquiry into alternative formulations is because the defendant sat mute in relation to that exercise. The defendant now comes before the court and says, here we go, have a look at paragraph 24 of our skeleton argument. Here we have all manner of suggestions as to what might have been done to formulate an implied term different to the one that the court came up with. That's very interesting, but it's far too late, and it's not appropriate for a point to be taken on appeal when it wasn't placed before the court in support of the proposition that the court erred in law below. And as an aside, there's another matter that's been raised only in the course of oral submissions that never was even hinted at before the court below, or the discussion we had this morning about the possibility of equal pay claims coming along across the horizon and how that might affect matters. Defendant was wholly silent on those issues at first instance. And when it is complained against us that we put forward a different formulation of the implied term ourselves, we say, so what? We were given permission to amend, that was consented to, that was ultimately the matter that the court considered when making its decision. Next short point, the injunction. This is to do with the terrorum point. I wonder if the court could just follow with me, just trace through with me how this happened in the judgment. This is important in terms of the terrorum point, and again, it's important from the perspective of whether there's been an error of law in the approach taken by the court below. So if the court could please turn to the core bundle at page 63, starting at paragraph 55. So that is where the topic is introduced. So following the preamble, where the judge expresses herself to be satisfied it's appropriate, she then, in the indented text below at capital A and capital B, she puts forward the formulation of what the relief should be. If you could just cast your eye down what she said there. Now if you look at 57 on page 64, paragraph 57, so what happened was she gave the parties the opportunity to make representations on the formulation of the injunction. Paragraph 56, having provided focus written submissions on the narrow point, etc., etc., she then turns to what she made of those submissions, and she says at paragraph 57, this is what the defendant has proposed. If you could please kindly cast your eye down what the defendant proposed and look at the wording that is scored through and the wording that is underlined.
But Mr. Gilroy, we're leaping back again from liability to remedy and indeed the detailed wording.
Yes.
Could we stick to liability?
Well, I'm about to turn to that. If you'll just indulge me for a moment more while I just kill this point off. The reason I'm doing this, my lord, is because I was struck by the nature of the discussion, as if to say that this perhaps was in terrorum, it was somehow impermissible, it was wrong, and I wanted to address that as soon as possible in my oral submissions.
They are suddenly complaining that they don't know what they can do with the unrelated, directly related, leaves them in fear of their life for 25 years. And you say, so what? They put the words forward.
I don't just say that, though.
Sorry.
It's a separate point. It's a separate point. Okay. They were given the opportunity to deal with that particular point, and the wording that they now complain of
is the words they put in.
Exactly.
Yeah, that's what I said.
I do beg your pardon. I didn't hear your lordship say that. I am sorry. That is the point we make. Now, the point we make there is very simple. They have to show an error of law. If they didn't cry foul at the time, and they are seen to have made amendments to other parts of the order, how can it now be on appeal that they complain the way they do? Anyway, there it is. So, responding to my Lord Justice Bean's suggestion, let's go back to what this is all about, the substance of this. So, the entitlement, we say, to retain pay was never expressed to be coterminous with the existing contract of employment. we say the opposite was the case. It was guaranteed to be permanent, and it was something that would endure for as long as the affected employee continued, quote, in the same role. It was, quote, guaranteed. The defendant had the option that it didn't avail itself of, found by the court, judgment paragraph 45 at page 60 of your core bundle. They could have put in a long stop. They didn't. They didn't make it clear. They didn't say, well, obviously it doesn't mean what it says on the tin. It's not lifetime, it's not guaranteed, etc. Nothing of the sort. Further, it could not be removed unilaterally, and that was what they were trying to do, and that's why we went to court, and that's why we're here now. But could only be removed by mutual consent. We make the obvious point, there are not many employees in the real world who consent to dismissal. So we say the meaning and intent was clear and unambiguous. The prevailing commercial imperatives at a critical period of expansion also...
Well, it was clear and unambiguous that it meant what?
What it said. Permanent, that it meant that the benefit was available, that the pay would be guaranteed at that level for employees.
I think you've got to look at 14, paragraph 14 of the judgment first to see what it says. In the clause that is said to be incorporated into the individual contracts, it describes various things. They're going to be confirmed in individual statements of employment, so it's not just in the agreement. It's an integral part of contractual terms. And then it says retained pay will remain a permanent feature of an individual's contractual eligibility. And the first question is, what happens if there is to be no contract because they terminate it, working backwards?
Well, if there is to be no contract and the no contract scenario arises from termination for cause other than getting rid of retained pay, then clearly the contract doesn't exist. So if the person steals £1,000 from the petty cash tin and is sacked for gross misconduct, that person can't avail themselves.
It's my fault. I haven't explained the question properly. We are looking at these words, first of all, to see what these words mean.
Yes.
And we've got the word permanent there. And I naturally read the words in front of permanent, and I read the words after it. What is to be permanent? What noun does it qualify? It qualifies feature. It's a permanent feature. Feature then of what? Of somebody's contractual eligibility.
Yes.
Subject to things.
Yes.
So I say to myself, well, that means it's got to be a contract, and it's going to be a feature of that contract, and it's going to be a permanent feature of that contract, unless it's changed in the way set out. So I say to myself, well, what happens if they terminate the contract? So there isn't a contract. It can't then be a permanent feature of an individual's contractual eligibility because he hasn't got it anymore, or she hasn't got it anymore.
I don't think that your lordship's formulation was badly put. I think we were an ad idem on that. If it's been terminated in circumstances that, and again, this is a circular argument, if it's been terminated in circumstances that do not offend against the entitlement...
No. This defines the entitlement. You can't build in what you want and say, that's it. I'm trying to work out what you're entitled to. And if you've got a contract, on one analysis, goodness knows we haven't come to a view, on one analysis, if you've got a contract, then one feature of that contract will be the retained pay.
Yes.
If you haven't got a contract because it's been terminated,
yes,
then it's got nothing to bite on.
Yes, but the retained pay, your lordship says, go to the words before and after. The words before, the paragraph before, retained pay describe what retained pay actually is.
Yeah.
That's what it's done. So it is, as was found below, it's essentially a pay capsule. It's the benefit of the old contract.
We know what it is. It's the difference in value between the old and the new.
Yes.
And the question is, how long do you get it for? And the question is, do you get it if the contract's been terminated?
Well, the words individual contractual eligibility naturally define it's got to be when the person's got a contract, of course. But that is not the same thing as saying that the right to the permanent benefit is somehow coterminous with the period of a particular contract. If the representation is, ad nauseam we have all the representations made about guaranteed, it's for life, it is forever, etc., 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 subject to the argument about the impact of those representations.
Can I just sort of focus on that a moment? So suppose for the sake of argument, that there had been written in here that retained pay will remain a feature for life. Now, on that basis, on the face of the wording, it wouldn't be the case that the right to retained pay ceased when the person had his hand in the till. But as I understand it, you accept that there has to be some qualification. It isn't the case that guaranteed for life or protected for life or whatever really means that you are in all circumstances entitled to retained pay for the rest of your life.
No, and I accept, of course, that if the person in my example with the hand in the till had been sacked for that reason, then plainly that would be a circumstances that would justify their dismissal, and that person would not be able to claim permanent retained pay.
So the question is, why not on your case? You say, well, we can see from the terms of this and anyway what employees were told at the time that there is a right to retained pay for life.
Yes.
So how do you reconcile that with the fact that the right to retained pay ceases when you're dismissed for gross misconduct?
Because the protection for life does not displace the ability of the employer in circumstances justifying termination, that scenario particularly summary termination. It doesn't disable and handcuff the employer from reacting to that employee in the way that one would normally in the absence of a retained pay benefit.
Can I just take it a stage further? Suppose you have an employee who wishes to soldier on in his 90s when he's really a bit past it. Is he entitled to have retained pay?
Well, he would be, in the sense that if the contract hadn't ended and the contractual relationship has to subsist on mutual trust and confidence. So in the, I regret to say, unlikely event that each party regard it as a meaningful relationship at that stage of that person's career, if they had reached that conclusion, the contract would still be alive.
But what if Tesco has concluded that really he has to go, but the employee wants to go on? Is Tesco entitled to bring the contract to an end then?
Well, Tesco would face potentially a number of challenges there in relation to the immediate possibilities of claim for age discrimination. So
But at common law, would the say 90-year-old complainant be entitled to say, I'm still entitled as a matter of contract to carry on in this job, and you've got to pay me the retained pay?
if that person had stayed in the contract and they had worked with Tesco, they satisfied Roman numerals 1 to 4 on page 44, paragraph 14, yes, they would.
I think you would say yes.
It wasn't the 90-year-old who at the time was maybe 50 who said, please will you now provide this benefit that contains all these fabulous promises. It wasn't the individual who promised that, it was the employer.
And just taking it one stage further, suppose, I'm forgetting now, everyone moved to Lichfield or Doncaster or...
Yes, I was alarmed at the thought of moving from Crick to Livingston. That would have been quite a move. It was, I think it was 45 miles down the road.
Yeah, so suppose now technology has moved on. There's no point in having these distribution centres. Tesco shuts them down. Can it do that?
I do beg your Lordship's pardon. Could you use possible? I'm sorry, I was distracted by something I shouldn't have.
No, I'm sorry. So suppose technology has moved on. Tesco no longer needs any distribution centres. It shuts them all down. Is the employee entitled to say, you can't. I'm entitled to remain employed and to have retained pay?
No. The employee, by getting this benefit in 2007 to 2010, did not suddenly become untouchable, free of any extraneous considerations of business life and the interaction between employer and employee. Of course he didn't.
So
What
why
he
not
gained,
if he had protection for life?
because the individual was entitled to the permanency or the permanence of the benefit because of the promises that were made as to the time that that would endure, not affecting the situation of someone who leaves and comes back. That person would be entitled to that benefit. And we asked the rhetorical question, why would they not be entitled to that benefit?
Well, you accept that if the employee is working Lichfield and Lichfield closed, then Tesco can say, well, we're dismissing you on the grounds of redundancy, and that would not be a breach of the contractual entitlement to
Yes,
retain.
I do say that, and the way that would work is because that person's legal entitlement would be as per what we obtained in this judgment. So we say that would have crystallized, and that person would not have been able to say, well, I have been wrongfully or unfairly dismissed, subject to the statutory considerations, because the dismissal is not related to the retained pay. It's because we're doing a reorganisation.
You say it's permanent in the sense that it can not be removed because you want to take away retained pay, whether you take it away or whether you dismiss the person, but it's not permanent in the sense that if there were other reasons why you would lose your job, or because you were dishonest, or because the depot was closed down on redundancy grounds, if it's removal for reasons unconnected with a desire for retained pay, that can't be done.
We say that we would have ended up with effectively the proscribed grounds that we ended up with in the judgment at first instance.
But that means the words protection for life and guaranteed for life, which are relied upon, can't mean anything, actually. Those don't tell you anything. It's nothing to do with those documents, then. It's to do with the view that there is something about the nature of this payment that is such that you shouldn't take that payment away.
Right. Let me try and approach it in this way. Tesco can't dismiss to remove retained pay. We say we're on all fours with Aspen, Hill and Briscoe. That's the first point. The second point, they can dismiss for, quote, good cause. Good cause, the implied term doesn't bite.
Yeah.
Number three, the reason for the dismissal does not relate to the removal of retained pay, and we can't object. So they can dismiss for example, using as a useful reference point potentially fair reasons for dismissal in the 1996 Act, capability, redundancy, or misconduct. What they can't do, Aspen, Hill, Briscoe, is dismiss because they don't like this retained pay anymore and they want to get rid of it.
Yeah, I understand that. I know that's the destination. I'm now looking at the various tube maps along the way. One of the things we've said tells us that that's what permanent means is the document that says protection for life. And then I say to myself, no, that can't have any help there because it's not the protection for life that gives it, because we know they're not protected for life. You've just told us that they're incapable, dishonest, or redundant. They can go.
Yes.
I say, well, that's not helping me. So then I turn to guaranteed for life and think, well, that doesn't help either.
Well, can I just pause your lordship there? Protection for life should help you because what that means is protection for life of the benefit, subject to the rules of the game.
Yeah, I've got to read other things in.
The rules of the game are, and we would have gone to court or the tribunal to establish this, and the best evidence of what would have happened is what happened in this case, and we would have got a declaration, or maybe that's being controversial in the light of the discussion, we would have had a finding on liability that that's what it meant. It was a right. They weren't entitled to terminate for the purpose, the avowed purpose, the expressly avowed, announced, declared reason of getting rid of this benefit. That is the key to it. They're not employee sitting in the warehouse saying, we are now completely protected, we've got this benefit, and it somehow isolates us from the entire sphere of employment law. We're not saying that for a moment. What we are saying with as much vigour as we can is that they can't do it to remove this benefit. And again, I repeat, we are firmly in the territory of Aston Hill and Briscoe.
Can we go back to redundancy? You've accepted, I think, clearly, rightly, that if an entire plant or distribution centre is shut, then the job goes and the retained pay goes, and the employer can properly dismiss on the grounds of redundancy. But suppose there is a less drastic redundancy situation where the plant or the distribution centre doesn't shut entirely, but the need for employees is reduced, say, by half.
I'm sorry, I missed that last bit. Reduced.
Suppose that the need for employees at a particular centre is reduced by half. You've no doubt been in many cases about unfair selection for redundancy in the tribunal, but at the moment we're not looking at a tribunal case.
Yeah.
We're looking at, do the retained pay employees have the privilege of exemption from selection for redundancy? Putting it another way, on the present state of the judge's order, if the Lichfield Centre, say, were to have its capacity reduced by half, and Tesco were to say, well, we'll get rid of the most expensive employees in our selection for redundancy, would they be in contempt?
They wouldn't be in contempt, because you would look at paragraph 3.2a and 3.2b of the injunction, which is at page 39.
So, in terms of the meaning of the contract, when it says a permanent feature of an individual's contractual eligibility, another thing to read in is if people are sacked because they're too expensive, and they happen to be too expensive because they've got the retained pay, that too would be an acceptable reason for the contract to be terminated and the benefit to come to an end.
Well, no, I'm not saying that. Because
sorry, I thought you were.
No, they were. I made it clear that B provides otherwise withdrawing or causing the withdrawal of retained pay from affected employees. That would be part of the stricture that the employer faced. But can I just say on this question, as it's been raised again of the injunctive relief, aside from what I've said on where is the error of law, because the defendant effectively put these words forward and did not complain about these words that were ultimately put into the judgment. Position as far as the injunction is concerned is this. Let me take up, for example, an observation by my Lord Justice Bean before the lunch break. In a point to my learned friend, so you, Mr. Gar, you say, if you lose everything else, you still win on the injunction because that injunction shouldn't have been granted. If this court concludes that that is something that should not happen, and there shouldn't be, to take my Lord Justice Lewis's point about is that something that they can be in contempt for, this injunction can be modified. It can be changed.
It's my fault. I should have made it clear. I'm looking at paragraph 14. I'm not into injunction. I'm quite slow, so I started off with what does the contract mean? And I'm looking at the third substantive paragraph of the contract at 14, which says retained pay will remain a permanent feature of an individual's contractual eligibility, subject to the following principles. And the question that I'm currently grappling with is, if you close half at a depot for redundancy, you only need half the workers. And if you decide to dismiss the most expensive workers, the workers with the highest salary costs. And if it turns out that quite a lot of those are people on retained pay, is that all right? So the words a permanent feature, there's another exception, i.e. you can't have it if you're made redundant and it's perfectly acceptable under the terms of the contract to terminate a contract on grounds of cost, where the cost is related ultimately to retained pay.
If it relates to retained pay, it can't be done.
Can't be done.
But can I answer that
Yeah.
in this practical way? This is Tesco Stores Ltd.
Mm-hmm.
When Tesco Stores Ltd, faced with a High Court injunction in the terms that we've got in this case, has to look at the retention or otherwise of warehouse operatives at any of these
I'm
warehouses.
not interested in the injunction. I'm trying to work out the meaning of the words first.
No, if you'll just indulge me for a second.
Yeah.
What they would have to do is they would have to consider as a business case what it would be legitimate for them to take account of in arriving at their selection criteria.
Yeah.
And the most perfunctory level 1 analysis of a human resource school, a trainee would say, well, just a second, that is going to be affected because we're taking into account item 1 on the selection matrix. It's pay. What does that relate to? Why is this person clearly of a different category to this person over here who hasn't got retained pay? The answer is because that person has got retained pay, that's a no-go zone, because that's retained pay.
The permanent feature means you can make them redundant completely because you don't need anyone in the place. But if you're making half of them redundant, you can't pick people on grounds of cost because of retained pay.
I do say that. That sounds...
I just want to know what your case is. I don't know, I haven't even grappled with whether it's right or wrong. I'm trying to understand it. I'm just very slow, Mr. De Go. You'll have to bear with me.
Yes, the way it's postulated, it makes it sound as though that's something that's unrealistic. It's perfectly realistic.
No, I'm just trying to work out. It's like asking, is it raining? I just want to know what the weather is.
Yeah.
I'm not interested in whether I'm going to go and have a holiday in it.
Yes.
I just want to know what it is. Right.
Well,
So,
we
but
say...
that's what you say it means. Permanent, you can have redundancy across the board because you don't need any work. But once you feature into the selection criteria, costs arising from retained pay, that's outside the scope of permanent.
Yes,
Yeah.
which I apprehend may result in a judicial thought process that's impractical or unrealistic, and I want to grapple with that and say it's not for a moment. If the case is of redundancy full stop right across the board, it's clear cut, no difficulty is presented. If it is the more poised halfway house postulated by my lord in relation to closing half and looking at pay, again, whilst it is not as simple as a lock, stock and barrel closure of the premises, it is not that difficult to understand that the reason someone is of a particular level of pay is because of the benefit that they've got, the benefit which at the moment is protected by an order of this High Court.
No, you must forget the High Court. I'm not interested in the High Court. I'm interested in the words of the contract. That's all I'm worried about at the
Yes.
moment.
Well, let me replace protected by an order of the High Court by saying protected by the entitlement.
The contract, yes.
Yeah,
So-
I've got it now. I know what you're saying.
Yes, I want to just turn to...
So the exceptions are dismissal for gross misconduct, dismissal for incapacity, and dismissal for redundancy, where that means the closure of the workplace.
Yes.
Right.
And it's quite simple. We say, although that sounds with the list as though a catalogue is being drawn up to make it impractical, we say it's quite simple. You take it back to first principles. What is protected? It is the right to retain pay. If that is the thing that's being impinged upon, that is the thing that they are not allowed to do unless it fits the criteria, Roman numerals 1 to 4, in particular on page 44, paragraph 14. Now, I want to deal with a mixed bag of points that are made against us on points of construction and the way in which that case is attempted to be made good by reference to certain cases. And I'll try and do this in short order, just so that you have our position on it. there is some reliance, and when I give you page references, my lords, here, I'm not inviting you to go there at this stage. There's not going to be enough time to go through these. Henriksen, the case of Henriksen, which is tab 3, page 113, that is relied upon by the defendant to say the word permanent is a relative term and it's not synonymous with everlasting. There's actually an error in the defendant's skeleton. They say that's Lord Green. In fact, it's Lord Duparc who said that. What do we say about that? We say that that case was very context specific. It doesn't assist the defendant. It was about whether disbursements paid by instalments could be deducted from the calculation of profit for income tax purposes. We have context in our case, and the best anchor point reference for that is paragraph 39 of our judgment, which is page 56. Wonder if you could just turn to that for a moment, where the judge at first instance in this matter starts the paragraph by saying, well, the word permanent, that might be considered to confer entitlement to be permanent as long as the particular contract endures, but she includes the crucial words devoid of context. Absolutely crucial, we say. I would invite you to actually physically or mentally highlight those three words. And we say that has a resonance when one reads Henriksen. I invite you to do so, to consider that, and to conclude it's a fact-sensitive case. It's to do with tax. In particular, page 196, there is a quote. For the purpose of your note, it starts, it is true that the period for which, if you can just find that when you're doing your research, it's all about the acquisition of a capital asset and how that is to be determined. Essentially, it's a tax matter. We also say, turning the tables on these points about the way matters were expressed, we say that there are, and this is tackling really the suggestion that somehow the words didn't mean what they say. Let's just look at it from the opposite angle for a moment. 4 points. If the defendant is correct, guarantee would mean the opposite. Permanent would mean temporary, or as long as the defendant wished, whether for arbitrary or capricious reasons or otherwise. The declaration that it could not be removed without mutual consent would be utterly bereft of meaning. You could simply click your fingers, to use the analogy with one of the employment cases where a school teacher was facing dismissal. The wording used there was, unless there was some protection here, the employer could snap his hands or snap his fingers and say, off you go.
When you say bereft of meaning, I had thought that what your opponent was saying this morning was it wasn't bereft of meaning. It had some meaning in the sense that everyone believed, and it may have been the law, that the contract could be changed by a majority vote on a ballot following a union-employer agreement, and that mutual consent had some meaning in that it at least ruled out that possibility.
Well, all I'm saying at this stage of my submissions, my lord, is that I'm making 3 short points as to why, if the defendant's interpretation of these words is correct, they have plainly ridiculous interpretations or meanings if the defendant's construction is correct. And I'm
I've got
saying
the first two. I just want to explore whether I've misunderstood what Mr. De Gever was saying this morning. I mean, do you accept? I thought he was saying that it was common ground between you, that everyone believed, and it may even have been the law, that the retained pay would have been capable of being removed following a collective agreement and a majority vote, and that the mutual consent had at least that meaning. Whether that would be enough is another question. But
I don't think that's right. I don't think that's right.
You don't agree with him?
No,
Right.
there's that part of the judgment which records the fact that one of the conditions was that when the employees were being told the extent to which the right was being protected, it couldn't be taken away unless there was mutual consent, it couldn't be taken away. It was taken out of the collective bargaining process.
Yes.
So that was my understanding of what the factual position was on the ground. I am simply saying, and it may be that one or more of these doesn't find favour with you. I am saying, just be careful with this terminology, because what you are being told is black means white, essentially, in this case. They're saying, if you strip it down to its bare essentials, they are saying that the words that we used, that we elected to use at the time when it suited us, because we needed to keep hold of you, it had this particular meaning. Now we're going to say something completely different, the polar opposite. If they had said to the workforce at the time that really it didn't mean anything like what they're now suggesting, if they said we never meant that, it wasn't serious that, they would never have got the thing through in the first place. Now that's not a hyperbolic jury point. It's a point of common sense as to what the thing actually meant at the time. We submit. But the fourth one is the reference to the entitlement to retain pay continuing in the same role, we say would be meaningless, because they would lose the right even though they continued in precisely the same role as the defendant had intended. Now, when one looks at the way the case is put on what I say is the pivotal ground, which is ground one, reasons explained, the repetitive assertion that is made that the judge's conclusion was wrong or simply wrong, we say amounts to nothing more than the defendant disagreeing with the judge's construction of the ordinary natural meaning of the words that were communicated. It provides no basis for your lordships to interfere with those conclusions. The judge was entitled to reach the conclusion that she did in the light of the undisputed facts. And you will have read from the judgment at paragraph 6 on page 42 of the core bundle that this is a Part 8 claim, so there were no witness statements from the defendant, not a single witness called by the defendant. So you have no evidence on context, not talking about intention, what they meant by the contract, no evidence about context. Secondly, no evidence about communications, and the defendant gave no evidence as to the purpose of retained pay, what it meant, what was the function of the benefit, why it was there, etc., etc. What the court was left with was a paper exercise that frankly was constructed by the claimants. So even though this is you're dealing with a defendant, Tesco Stores, one of the leading retailers in the UK, the evidence emanated from the claimant's side. That is, I say, at least an interesting background factor. Now, let's look at one. There's two particular points of construction that are taken that we challenge. First of all, it is said that permanent simply means permanently removed from the sphere of collective bargaining. And the second point is it is only to subsist, that is to say the entitlement is to subsist for the duration of the contract. And for your note, and so it's on the transcript, I'll give the references in my learned friend skeleton, paragraphs 4, 6 brackets 2 and 3, 8, 10 and 16.2. And in fact, you might include also paragraph 11. So it is the thread that one sees throughout the defendant's written submissions, this question of the linkage between the adjective permanent to collective bargaining and its removal from the sphere of collective bargaining, and in the alternative, the full duration of the contract. Now, what we say about that is, let's first of all look at collective bargaining. If you can go, please, to volume 3, tab 32, page 623. That is the case of Anderson.
This is Lord Justice Maurice Kay's
Yes, it is indeed.
formulation, which is quoted in another of the judgments.
It is. That's a feature, my lord, of several of these cases. We
It's
see
the
yet
same
again.
as Hoffman in Chartbrook, except that it's in the context of an employment case and collective agreements.
It is. And so there's no particular science to this, although we do say, for your note, paragraph 22 at page 626 is important. What meaning would the pay and conditions agreement convey to a reasonable person, etc.? If we just ignore the next few lines and take it up the sentence that begins, the idea that the unions would agree, if you're on page 626 of your authorities bundle. Yeah. I thought your lordship said, we were certainly told 2 days ago, an electronic bundle was...
I dare say, but
I think it came yesterday,
I prefer...
but by then,
You'd march your bundles up.
yeah, but I mean, and to be honest, some of us, not my colleagues, are of such an age now that paper bundles are still preferable.
Well, you're preaching to the converted there, my lord.
Yes,
But
and-
even
and-
I grappled with this electronic bundle.
And me. Anyway, I found it.
626.
tab 32. Yes.
So, begins, what meaning would the pay and conditions agreement convey to a reasonable person, etc., etc. A few lines on, the idea that the unions would agree to a 3-year deal in which the 3rd year was covered by 2 alternatives and that the employer should have the unfettered right to choose between them strikes me as fanciful. I'm quite sure it would have struck the employer as equally unrealistic. And he said that the construction flouts industrial common sense. And we say it would indeed make no industrial common sense, industrial relations common sense, if the term could not be bargained away in collective bargaining, but yet could be unilaterally removed by the defendant. That would simply not accord with common sense and cannot conceivably be what the objective intention was. There is no evidence, hardly surprising, no evidence that the union said, okay, we'll take it out of collective bargaining, but tell you what, you can remove it when you like. So it's a hopeless point, we say. And there is, if I may respectfully say so, a tour de force description of that particular point by reference to that authority, the judgment in this case at paragraph 40. Another case that is argued to support the case against us is Ali and Christian Salveson. That is in your authorities bundle, volume 1, tab 13, page 271.
Sorry, you were saying of Anderson that there was a tour de force.
Paragraph 40.
40? There isn't a paragraph 40.
Have I got the wrong paragraph number? Do forgive me a second.
Do you mean in the main, in our judgment?
Would you excuse me a second? Yes. It's the judgment I was talking about. I want
Yes.
to make sure I'm making the right point here.
Do you mean paragraph 40 of...
Yes, page
The judgment
57, my
where
lord.
it
Page 57.
Yep.
Do forgive me. Yes, sorry. The point is, I described it incorrectly. I maintain it is effectively a tour de force by reference to that authority. It doesn't cite the authority. But if you read what she says, that is what she is talking about.
Yes.
So the preliminary part of paragraph 40, true it was, the intention encompassed an intention to remove the entitlement from the collective bargaining machinery, etc., etc. But that was not the full extent of their intention. It is clear from the undisputed evidence in this case, etc., etc., etc.
Was there any argument before the judge that the pre-contractual documents in February 2007, thereabouts, were inadmissible?
No.
Was there discussion as to the purpose for which they were admissible? Or did everyone just read them?
Obviously, very careful not to mislead you one iota. Can I just confirm with Mother Junior?
Yes, of course.
Because we were both obviously
You were
involved.
both
Yes,
there,
you are.
the others weren't.
Do you excuse my back?
Yeah.
Our recollection is that there was simply no discussion on it. The matter proceeded, the evidence was put in, the evidence was compiled in a fairly short timescale because this was, it was actually a speedy trial.
Yes.
And I know that, I know that the case perhaps then gathered a different timescale, but that is the explanation, and certainly as far as conducting that exercise today is concerned as to how it's relevant, I defer to my discussion with my Lord Justice Newey on why it matters and why we can refer to it, its context and background, and it would have informed the reasonable person with all the background information as to what the meaning of the clause or the meaning of the term was. So I wonder if I could go to Christian Salverson, Ali and Christian Salverson, Volume 1, Tab 13, page 271. And I believe that what is relied upon is at page 276. And I don't have a paragraph number here, but it's the paragraph that starts, should there be any topic? Apologies.
726.
Is it 726?
Yeah.
Yes.
Oh, sorry.
Letter C.
726 at C, I'm grateful. Sorry, I directed you to page 271. That must be a mistake as well. Anyway, page 726 at C, should there be any topic? If you could just cast your eye down that, my lords, down to the words to take account of it. So, what is being said here by the defendant is that this case means if an agreement is silent, you don't imply a term, you conclude the agreement was silent for a reason, or it is a better conclusion that there was a reason for the silence, or at least as a minimum, it is as good an explanation as there not being a term expressly incorporated. We say that is totally different to this case. We invite you to consider the factual matrix again in this case, Ali and Christian Salverson. In that case, many imponderable contingencies had to be catered for. A whole range of possibilities. And we find that, and I've got another incorrect page reference here. Just excuse me a second. What does Wade say this was an agreement? In that case, do excuse me.
So the same page?
Yes. Do beg your pardon, the page numbering has gone awry here. I think it's 726. Is there a paragraph? This was an agreement which by its very nature.
Yes, it's the next paragraph, second sentence.
Thank you very much, my lord. This was an agreement which by its very nature would require it to be applied to many eventualities that it did not and could not realistically cover specifically. When regard is had to the immensity of the task of legislating for every eventuality resulting from such termination, there are numerous possibilities. The court was being asked to fill just one of many gaps in respect of which there were numerous ways in which they could possibly be addressed. We say that the situation is materially different here in terms of the representations, or at least to avoid that territory, not the representations, the meaning of what was understood objectively to be what was being introduced by way of this significant benefit at the time. Second point of construction is this idea of the entitlement being tethered to that particular contract. We say on that there is no particular way in which, in either the initial or the revised skeleton, because we've had two skeletons here, the one for permission to appeal, separate counsel, so 4 separate counsel instructed, we say that they don't really engage with the meaning and effect of the statements made by the defendant when retained pay was introduced and agreed. And we say we're not in difficult territory here of ambiguity and competing meanings. The point you have, by reference to all of the reference points, the actual documents themselves, you're very familiar with those. They're referred to in the judgment. I see no benefit in taking you to those. If the defendant had told the workforce this benefit was like any other term which could be unilaterally removed by issuing notice and offering re-engagement, it would never have got through. It's for that reason that the matter was cemented by permanence, and the position is, as clearly demonstrated by the actual evidence rather than speculation by lawyers years after the event, the linkage here was to a different temporal marker, namely continuation in the same role. Not continuation in the same role, leaving, emigrating to Australia and coming back 10 years later and taking up the same role, continuing in the role.
But how far does that take you? Because if the contract is brought to an end, the role stops. So, I mean, suppose Tesco weren't seeking to dismiss and re-engage, but just to dismiss. Would that be legitimate?
Dismissed for what reason?
They don't tell you. They just write and say, you're dismissed.
Yes, but
you
then,
ask why and you say, I'm not going to tell you.
Yes.
If you sue them in the employment tribunal, then they've got to establish the reason. But we don't know at the moment.
the fact that we don't know at the moment, I would say, is nothing to the point. There has to be a reason, unless it is so capricious. They've just decided that because someone is wearing blue shoes and not brown shoes one day, they should be sacked. Now, we can't force them to tell us at the time. We can't even force them to tell us if we take them to the employment tribunal or the court.
How does the contract work then? As my lord said, if the contract is terminated, that's all you know. You've had notice of termination. And as my lord says, that means the road is at an end. The contract is at an end, the road is at an end, and that's it.
That's
From
it.
the point of view of the contract.
From the point of view of the contract, the individual would be bereft of any reasoning as to why he'd been sacked. Quite unusual, but I accept the possibility, a 1% possibility that it could happen.
We're doing it for the hypothesis of testing the meaning of the contract. So don't worry about the real world.
Yes.
We've moved away from planet life to planet law.
Yes.
And on planet law, that's what you've got. You're working out the meaning of these words, and you're sacked, and the question is, well, you're not on the same role now.
Yes, it presents no difficulty whatsoever, because at some point, the only way of ascertaining the reason is through some form of legal process.
Can I try to sharpen the debate a bit? Suppose that Tesco decides to dismiss because they think the individual is being paid too much, possibly because he's getting retained pay. So they give notice to terminate the contract. And with the termination of the contract, the role comes to an end. Does that mean that the right to retained pay comes to an end?
No, it doesn't. Well, as a matter of fact, it does, because they've sacked them. Because they've done something that they shouldn't have done. That if we had wind of that before it happened, we would take action
So-
rather in the way that we did
so-
to stop it.
Just to be clear, you say if Tesco decided to dismiss somebody because they thought he was being paid too much, then that would be a breach of contract.
If it was
even
because
though-
of retained pay.
Even though the role came to an end. So why would it be a breach of contract when the role had come to an end?
Because the individual would be being dismissed because they're in receipt of retained pay.
But that's sort of a bit circular. I'm just trying to understand, what is the contractual right? Your contractual right is to keep your retained pay for some period. And I think a moment ago you said your contractual right was to keep your contractual pay while you were in the same role. But if your role has been terminated because you've been dismissed, where is your contractual right to the retained pay?
Well, it's gone because you've been sacked in the first place. Because they've ridden roughshod over whatever your entitlement is and they've sacked you. You've gone, so their right to retain pay, yes, it's to do with the role, but if they are using and exploiting the fact that it's the pay that means the reason the person should not remain, it's quite simple. They're using the fact the person is on retained pay to get rid of them.
Yes, but that's not the point. The problem is they have got rid of them. And if the retained pay needs to be linked to a contract, even though they've been terribly unfair at getting rid of you, they've got rid of you, and there's therefore no contract to be a permanent feature of.
Indeed. So what you have to do is keep your wits about you, learn on the grapevine what's going on, realise that managers are talking about getting rid of it, get on the phone to your union representative and get them to go and get an injunction in the High Court.
That is going back to how you can stop people being naughty. The question is, are they being naughty though? Even though we don't like what we're doing on this hypothesis, if it's tied to a role, and if the role goes, then the fact that you might or might not have known about it in advance and might or might not have taken steps is irrelevant.
Well,
the question is, on the definition of permanent feature, what does that mean? And one's got to address the question of, is it tied to a role? If it's tied to a role, what does that mean? Because the role is a role under a contract. And if there is no contract, there is no role.
Well,
So it's got to go beyond a feature of a contract. This contract or any further contract of employment that you have, it's got to go beyond that to, and furthermore, we will not terminate the contract.
yes. A number of different scenarios in the course of argument have been postulated. I say that in relation to each scenario that is postulated, you bring it down to basic essentials. What is the reason for the action on the part of the employer? If the reason for the action on the part of the employer is to dispense with something that they said to that employee in 2007, this is guaranteed for life, in the role, forever, permanent, for as long as you are there, then they can't do it. If it is to be established upon inquiry, judicial or otherwise, as to what the true reason was, and it did not offend against that right, which is, we say, enshrined in their contract, it did not offend against it, they could not complain. And I go back yet again to the position, which is they do not sit in the staff canteen at Daventry Clothing with a bubble round them saying, don't come near me, I'm protected, you can't touch me. Anything to do, if there's a scintilla of a hint that this program or what you're doing, or you're bringing in new working practices that make me not want to stay here, if it's got to do with pay, that's plainly ridiculous. They're not suggesting that. They're saying that is our benefit, you brought it in, it was your idea, you needed to do it at the time, otherwise we'd all have left, you'd have been up a gum tree, we stayed, your side of the bargain is now to honour the promise that you made. It's as simple as that. I say it's as simple as that, clearly. In planet law and in planet real world, there can be scenarios postulated that test that, but that's nothing unusual. in the sphere of employment relations and employment law.
Go back to the question of reduction in the workforce. They're not a complete closure of the plant. Mr. Kumar and Mr. Webb were flexible warehouse operatives whose basic hourly rate of pay in 2007 was £8.50 for the first 36 and a half hours. But Mr. Jagpreet Singh was warehouse operative, not flexible, so a lower grade, and £7.50 an hour basic rate.
Would your lordship forgive me? Wait, can you just say which paragraph you're looking at?
I'm looking at the 3 individual contracts.
Yeah. Oh, you're actually looking at the documents themselves.
I'm looking at so take Mr. Kumar, tab 7, page 34.
Thank you very much.
Well, job title, flexible warehouse operative, and £8.50 and a half pence
Yes.
an hour. Likewise, Mr. Webb, that Mr. Jagpreet Singh, tab 9, page 42, is on a lower grade, simply warehouse operative. Now, suppose that Tesco decided to abolish the grade of flexible warehouse operative. They could say to Mr. Kumar and Mr. Webb, therefore, you are redundant. You're not going to be replaced. This isn't a sham. We are going to streamline the workforce by abolishing this grade. Now, are they allowed to do that or not? Is it a breach of the retained pay contract?
Well, I don't think there's any mileage in this point with respect, my lord, because if we look at Mr. Singh as the example, starting at 42, the whole point about retained pay is he gets at the top of page 43 that sum. So if you're going to interfere with something that happens further up the contract, the thing that is protected is the thing at the top of page 43. That's the whole point of the protection.
No, but I'm looking at the situation where Tesco say to Mr. Kumar and Mr. Webb, we are abolishing the job grade flexible warehouse operative, and we are reducing the workforce by eliminating all the flexible warehouse operatives at Lichfield, Daventry. Therefore, you are redundant.
Yes?
Now, is that a breach of contract or not?
Well, if they have taken into account, if I stay with Mr. Singh and his terms and conditions at 42 onwards, if they are taking into account as the reason why he's redundant what appears at the top of page 43, that's a breach of his rights. That's a breach of his entitlement. They can't subject him to less favourable treatment because of interfering with the right that he's got to retain pay.
And just to be clear, suppose there are, 100 flexible warehouse operatives all on the higher rate of pay. And Tesco decides to get rid of all 100, and one of them happens to have retained pay. Is that all right or not all right?
It's probably, I venture to be careful about this, it's probably okay because they're doing it for a collective organisational reason right across the piece that does not involve Tesco getting rid of someone because they've got retained pay. What we're complaining about here, what the mischief is being actually targeted here because you've got this benefit.
Well, certainly they couldn't, on your case, they couldn't say, we'll will make redundant all the retained pay flexible flexible warehouse operatives and keep the rest. But the example that Lord Justice Newey gave is a more difficult one. 1 out of 100, 10 out of 100.
Oh, one could go on with a workforce the size of this employer. But to use my Lord Justice Lewis's expression, in planet law, we grapple with these things. We grapple with these scenarios, however difficult they are, to reach a proper and just conclusion.
You say the ultimate test is if the real reason why somebody is going is the retained pay.
Yes.
That's it. It's not allowed.
This is no different.
If it has an effect on somebody with retained pay, they get rid of the people with the shortest level of service, and 4 of the 60 people with short service happen to be people on retained pay.
Yeah.
It's unfortunate, but it's nothing to do with them having retained pay, it's them having short service. There may be difficult borderline cases, but you say the purpose of the guarantee, and therefore the contract must be read as protecting people who are on retained pay. Protect them in the sense of you can't take it away whilst they remain employed, and you can't dismiss them whilst because of the reason.
Yes, and on that I say this is no different to the many-fold situations that we get in employment law where a tribunal is asked, what was the real reason for X?
Yeah.
Whistleblowing, a classic example, the reason or the principal reason. Goodness knows how many examples there are. There it is. Right, I'm conscious of time. I want to grapple with another point that is taken against us, which is this idea of praying in an obvious commercial sense. And in that regard, Arnold and Britton is cited, the well-known speech of Lord Neuberger in Arnold and Britton, tab 3, volume 3, tab 36. And constraints of time prevent me from simply reading that out, but it's paragraphs 15 really through to, I suppose, 22. Certainly haven't got time to read that out, but if I had to pick a particular paragraph, it would be 20. There are 5 different factors outlined. Paragraph 20. While commercial common sense is a very important factor to take into account when interpreting a contract, a court should be very slow to reject the natural meaning of a provision as correct, simply because it appears to be a very imprudent term for one of the parties to have agreed. Even ignoring the benefit of the wisdom of hindsight, the purpose of interpretation is to identify that parties have agreed, not what the court thinks they should have agreed. Experience shows it's by no means unknown for people to enter into agreements which are ill-advised, even ignoring the benefit of wisdom of hindsight. It's not the function of a court when interpreting agreement to relieve a party from the consequence of his imprudence or poor advice. Accordingly, when interpreting a contract, a judge should avoid rewriting it in an attempt to assist an unwise party or to penalise an astute party. Well, it's a phrase that's been used by the court today, and I therefore feel more comfortable in using it. That is bang on what you've got here. That is bang on what learned counsel has urged upon you when he postulates the scenario of agreeing something in 2007 and somehow it endures many, many years into the future. Tough luck. That is the consequence of what you not only agreed, but you actually promoted to be agreed in 2007 onwards. And the other point on commercial common sense, often overlooked, I'm sorry, there were 6 points there going through to paragraph 22. The other point to bear in mind is that it is a factor that must be tested at the time the matter was agreed. So it's commercial common sense when the term was introduced, not commercial common sense when down the tracks you suddenly look at your books and say, why did my predecessor or someone 3 before me decide that stupid benefit? It's totally irrelevant. They could have used different language, they didn't. They could have given caveats, they didn't. And the timing is important. Consistency with other express terms. We say the suggestion that the defendant's construction is consistent with other express terms is at best a distraction. There was no evidence presented before the court of any comparable guarantees being given in respect of any other term, and none of the other terms are expressed in similar language. So we invite this court to endorse the judge's analysis on the express term issue. Implied term. You have my point on the structure of the appeal, and I say we don't get there unless my learned friend succeeds on ground one. So, assuming without prejudice to all of that, he survives the scrutiny of the first ground of appeal. The critical question is whether or not it's necessary to imply a term in these circumstances. And we succeeded below on two separate tests, business efficacy and officious bystander. Now, it's fair to say that many of the cases say it's a rarity to find only one.
Can I just try to be clear about the premise? You say, well, Tesco only gets to this if they've won on ground one.
Yes.
So are we, as we now turn to your submissions on ground two, assuming that Tesco has won on ground one?
Yes, for this, I've got to make submissions on that if I'm wrong about their position on ground one.
So at this stage, we assume, do we, that under the terms of the contract properly construed, the right to retained pay ceases when the contract is brought to an end?
Either that or the other formulations that have been put forward, such as it ends when it's linked to collective bargaining.
But the necessity for the term, if Tesco win and the retained pay needs to be part of either the current contract of employment or at least a contract of employment, then we go on to the question of how do you stop them terminating the contract? And that's why you need the implication of a term that says not only must you include it in an existing contract of employment, but there's an implied term that says you can't bring the contract to an end for reasons to do with the retained pay.
Yes.
So you need both. Yeah.
Yes. So, a well-worn, well-trodden route, Marks & Spencer, BNP Paribas, Allied Petroleum Company, U-Design, and one can do no better really than turn to the judgment, because the learned judge at first instance goes straight to the U-Design test and quotes it in full. Page 57, paragraph 41, therein set out paragraph 41 to 51 of U-Design. Goes through all the relevant tests, and in particular at page 58, paragraph 49, the reference by Lady Justice Carr in the U-Design case to the Marks & Spencer case. So these are milestone cases, they're seminal cases. I'm not going to go through those. What I would say is that it is instructive to consider paragraph 21 from Marks & Spencer and BNP Paribas. Haven't got time to go through it, but I would say you have got there set out 6 different principles. All of those are directly relevant. There is a reference, obviously, to the officious bystander, and that's factor 5 when you get to it in your deliberations, paragraph 21 of Marks & Spencer, factor 5. And what I would say about that is that the question to the officious bystander needs to be extremely precise when the officious bystander test is being considered.
Is it relevant or is it not relevant that the contract as agreed between the union and the employer does not include the words along the following lines: retained pay will remain a feature of an individual's contractual eligibility, and the contract will not be brought to an end for reasons to do with retained pay.
Sorry, my lord's question is?
They say, if you look at paragraph 14, the third thing, retained
Can I just
pay
ask
will-
what page your lordship is on?
paragraph 14 of the judgment. I've got it in the ICRs, I don't have it.
Oh, yes, yes, yes.
And it says retained pay will remain a permanent feature of an individual's contractual eligibility, but there's nothing there that says, and I'm asking whether it's relevant or not, and that eligibility will not be removed for reasons to do with retained pay.
Why would it need to be there is my rhetorical question.
Yeah, that's what that's what you say. You say you don't
Yes.
need to have it.
Yes. So, moving on, there's obviously a tension between the permanency of the right to receive retained pay and the power to issue notice. So, there it is. That opens up the debate. You have my point about the concession that is now made that Malik is not a brick wall to the argument that we advance, which was accepted below, which is that it is not wholly unfettered, the right to simply give notice. That's an entirely circular argument. A term can be implied which regulates the manner in which an employer is able to exercise its otherwise apparently unfettered power to terminate on notice. And we say this is not simply seen in the setting of a PHI claim. There are legion cases in the education, teacher misconduct, gross misconduct field. There are actually two cases, regrettably, we've not put in our skeleton. I'll mention Irani, 1985, IRLR 203. Quite a well-known case. It's simply the bypassing of a disciplinary procedure.
But these are there are cases too numerous to
Yes.
mention
Yes.
about where the employer is contractually bound to follow a particular procedure and has failed to follow it.
Indeed.
And an injunction can be obtained that until you've been through the procedure, you can't exercise the right to
Yes,
dismiss.
and it's usually seen in the context of discipline. It's
Yes.
frequently seen in the case of doctor's discipline.
Yes.
It is also frequently seen in capability procedure, the right to go through that. It's also seen in redundancy. For example, we have in front of us the Genvy case. So very simple point here, 2 points. Malik is not the brick wall the defendant says it is. And secondly, the areas in which it has been accepted, as it was in this case at first instance, that it is permissible to reconcile the tension between the right that I'm contending for and the right to give notice, is firmly well established. It's not appropriate for it to be swept away and simply described as a flimsy basis of reasoning based upon PHI cases.
I'm sorry to derail your train of thought, Mr. Gilroy, but
Not at all.
something is on my mind and I must ask about it before we part and forget. The chronology as set out in the judgment is that the various pre-contractual documents are all February 2007, March 2007. Then the individual contracts of employment, which we have in the supplementary bundle, are also 2007. But core bundle page 91, Litchfield Pay and Conditions, is 2010. Now, I would guess there must have been a 2007 version, but maybe not. One of the points Mr. Degar Robinson made, rather in passing, was, well, these statements were all made 3 years previously. What happened or didn't happen in 2007 on the collective front?
Well, as I stand before you, clearly on my feet and reacting to that question, I do not have that information at my fingertips. I can take instructions on that.
Could you?
I have to say, I honestly do not recall. If you ask me what's the best of my recollection, it is that it was closely followed. The need to get the warehouse move was obviously temporally connected with the discussions about bringing this benefit in, and therefore it had to be dealt with straight away. That's my recollection. The deficiency in that, I accept, is that that's not backed up, certainly not immediately, by evidence. Can I just ask if that can be
Yes.
something that is just looked at? Because I'm
Mr.
conscious
Britton,
talking about when we part company, it's now 6 minutes, certainly in planet law over here it's 6 minutes to 4.
Yes.
That's
I
what
just
it's owned
inquire-
to planet, that clock. It's
Yes,
not
I think I'll go with
Yes,
I'll
so
say
I-
that.
Never mind that clock. You're right. It's
Could I just inquire, because I have
Yes.
to allow my learned friend to at least touch upon
yes.
Estoppel, and I have to allow my other learned friend to have a short reply. Could I just respectfully inquire what is the likely time the court will rise?
Well, we'll sit to finish, but see if Mr. Brittenden or anybody else knows the answer to the question
inquiry
I just
is already
asked.
being considered.
And subject to that, are you in a position to hand over to Mr. Brittenden to deal with Estoppel?
Well,
There's
I
a
hope.
question Guy asked about paragraph 55 and why would there not be a contractual right?
Yes,
Damage.
yes, I am.
Sorry.
Yes.
Disappointingly, I have actually got a few other things I wanted to say of substance. May I be permitted 5 minutes to do that
Yes.
before I address that,
Yes.
that paragraph 55 point? So, really, as a whistle stop, it has to be a bullet point whistle stop. Aspden is key. Aspden, for your note, is Volume 1 Authorities, tab 12, page 265. It's paragraph 14 on 268. That's where you find the implied term. Paragraph 15, the last 8 lines, he talks about the mutual intention that the dismissal would not be operated to remove the accruing or accrued entitlement. The solution he came up with, so this is what I think he called the reconciliation, is at paragraph 21 on page 269. See in particular paragraphs B and D on that. It's then followed by Brompton, Volume 2 of Authorities, tab 14, page 278. I'm just reeling this off for your note on the transcript. The well-known obiter observation of Lord Justice Staunton at 281-282, expressing support for Aspden, saying there's a good deal to be said for such a term, which has the support of Mr. Justice Sedley and Aspden. You then have Hill in the Outer House of the Court of Session, Volume 2, tab 16, page 307. Exactly the same territory. This time it's sick pay and permanent sickness. Particular highlights are paragraphs 10 and 12. Paragraph 12 on page 309. Paragraph 20, for your note, is what Lord Justice Ward later adopts in the case of Briscoe. So this is the way that the jurisprudence is developing. It's a particularly important paragraph, paragraph 20 and paragraph 21. And there was a rejection of the argument that anything turned on the fact that a separate contract existed between an employer and an insurer versus a situation where the employer was self-insured. I'm not sure that point is particularly pursued.
No.
We then have Vilela, tab 18, page 347, business efficacy, disability entitlement, plainly on all fours, factually distinguishable, but plain on all fours. Then, importantly, we go to Briscoe because it's Court of Appeal, 2002, Lord Justice Ward, Volume 2, tab 20, page 388. A soundbite, if I have to have a soundbite from the case, it's paragraph 107 at page 400, the principle to emerge from those cases is that the employer ought not to terminate the employment as a means to remove the employee's entitlement to benefit. We say we fully occupy that territory. And we now have, I submit, a substantial line of authority. The learned friend relies upon Chapman and Honig, volume 1, tab 4, page 131. That's a landlord and tenant case, largely devoted to contempt of court. We have a judgment in that case where the defendant in this case relies on a proposition that simply does not derive any weight from that case. We say it's a circular argument. It fails to address the antecedent question of whether or not the defendant has the contractual right to terminate so as to remove retained pay. And I ask you to give careful consideration to that case to see whether in fact it is very much context specific and fact specific, and actually whether it takes the debate any further forward rather than the substantial line of authority that the claimants rely upon. The other case that you have obviously is Awan. Now that is of, I respectfully submit, considerable weight. A decision of the then president of the EAT, the then Mrs. Justice Simler, now of course a colleague of yours in this court. A term may be implied to prevent the employer depriving the employee of the benefit of a long-term disability plan by the application of officious bystander and business efficacy tests. I commend that judgment to this court, and in particular, and this is paragraphs 42 to 46, where I gain support, I respectfully submit, for the propositions I advance in this case. And that's really where she conducted a review of many of the cases that I've referred to and we are relying upon in this matter. Gen V, different area redundancy, the then Mr. Justice Elias, volume 2, tab 23, page 429. I commend in that case paragraphs 19 and 20 for your consideration. It talks about the way in which the implication can occur. It says it must be narrowly circumscribed. Totally accept that. We say that we meet the test in this case. We meet the threshold. Make sure I'm... Yes. Just excuse me a moment. Very briefly, we say that the case of Reader actually supports our position rather than the defendant's, volume 2, tab 22. In particular, the speech of Lord Millett at page 418 and paragraph 48, where he records the fact in support of the conclusion he draws in that case that Mr. Justice Sedley, as he then was satisfied on the evidence. It was not the employer's intention to exercise the contractual right in circumstances where to do so would frustrate the employee's entitlement to income replacement insurance. The question was whether it was an implied term of the contract that it should not do so. And he talks about the reconciliation exercise that I've referred to in the course of my submissions. Finally, the defendant relies upon the case of Lloyd, volume 3, tab 33, page 628. The one example that Millennium Friend has found where the term was not implied in a PHI case, they found one. The broad statement in that case to that effect must be considered in context. there was an appeal, and one of the grounds was it was an implied term. The employer would not terminate as a means to remove the benefit. Interestingly, given the fact the case is cited, the Employment Tribunal found he'd actually received all the benefits under the PHI policy. So, concluding matters on ground 2, we say we invite you to accept the analysis of the High Court. We say it would indeed subvert the permanence and intended purpose of the commitments expressly given and intended. We say the judge was correct to recognise the compelling grounds upon which it was necessary to imply a term. And we say it was necessary to imply a term to preclude the defendant from acting in a manner contrary to the mutual intention of the parties. We say in very short order, subject to the points I've made about addressing inter orum and my fallback position on the availability of a modification to the relief if the court finds in principle that the relief granted is in some way disproportionate, to put it one way, or excessive, to put it another way. That is the proper route. The proper route is not, if the court is with us on the substance of the appeal on liability, ground 1 and or ground 2, the right way forward, we respectfully submit, is not to dash away the essential remedy that was obtained first instance, which is the declaratory and the injunctive relief. And we say that once we had succeeded on liability, it was a very short skip and a hop to the conclusion that declaratory and injunctive relief was appropriate. And you have my point about discretion. To succeed on either of the aspects of relief, my learned friend has to persuade you something's gone wrong here with the exercise of discretion. That's a big hurdle to get over. Discretionary remedy, injunctive relief, something terribly wrong has happened. The judge has relied upon something that she shouldn't have done, or she failed to rely upon something that she should have done. And I say that test is not made out. I'm conscious that I have to come back on one particular point. I've been just in discussion on my feet with my learned friend about that issue. Can I do it this way? Can I ask my learned friend to deal with this Estoppel, and I'll come back in very short order on paragraph 55.
Well, why
Is that
don't you
acceptable?
just deal with paragraph 55 here and now, and then hand over to Mr. Britton.
Just excuse me a moment.
Yes.
Yes, I'm going to make a further suggestion. Would it be acceptable if Mr. Britton dealt with that point as well?
Yes, certainly. Right, thank you, Mr. Gilroy. Mr. Britton.
Yeah, my lords, yes. Mr. Gilroy's got my notes and my authority.
You've got to learn it by heart and do it on your feet.
My lord, yes, addressing you on paragraph 55, page 63 of the core bundle. And if I heard correctly, the suggestion was that the judge made an error of law, misstated the legal position as to what the claimant's remedies would be if notice was given. If one looks halfway down paragraph, well actually if one looks 4 lines down paragraph 55, such a cause would operate to remove a significant portion of the remuneration currently payable to the affected employees, causing significant injury to their legal rights. Damages would not be an adequate remedy in that event. And here's the key words. Given that, assuming that proper notice were given, their remedy would be limited to the losses recoverable in any claim for unfair dismissal, with all the difficulties attendant upon such a claim. So just to unpick that, the judge was operating on the premise that Tesco would give lawful notice, therefore the employees or the claimants would have no claim for wrongful dismissal.
But surely that's circular. If the judge was right to grant a declaration, then it would be a breach of contract for Tesco to dismiss any of the claimants. If the judge was wrong, then the claimants have no cause of action at all.
My lord, that's when we come on to the the Johnson exclusion area. I can take this very, very shortly. But
Well, nobody's mentioned that. Speaking for myself, I don't think Johnson and Unisys has anything to do with this case.
well, my lord, it's just to address the point
Yeah.
that respectfully the
It's
judge.
the amount of money you get, that's the problem. No matter how much notice you give, on the judge's finding, you can't sack people on her finding because they get retained pay. If you do sack people, what's the consequence? They've got a claim for damages for the pay. And if they've got 20 years of employment, it's 20 years of annual retained pay. And that isn't limited to what you would get on an unfair dismissal claim. That's the problem that I've got with that sentence.
Lord, just to clarify, the position that you've indicated in terms of damages, that's premised upon a claim at common law, claim for breach of contract.
Yes, exactly.
Yes.
To clarify, that claim is not permitted by reference to Johnson, Unisys and Edwards and Chesterfield.
Okay.
If Johnson and Unisys precluded, Lord Hoffman speech precluded an employee from relying upon the implied term of trust and confidence in relation to a claim for post-termination losses caused by their dismissal for essentially policy reasons. I can perhaps clarify this in a moment, but that's for policy reasons because it would impinge upon the ground set down by Parliament by the introduction of the statutory right to bring a claim for unfair dismissal. So that means that an implied term can't be relied upon to claim post-termination damages. The fact of termination limits the losses to notice pay. If you've received your notice pay, you've got no claim at common law. Edwards and Chesterfield, it
For the
might
period
assist-
that you would have got notice for, but this is something different. This is a different right. This is the right to be paid until you retire a certain amount of money per year, and you haven't got it. So you sue for it.
Well, my lord, that's contingent upon whether there is a dismissal and whether that dismissal is effective. But the key point is, if one assumes the situation as unfolded, or as Tesco wanted it to unfold, Tesco issue notice to terminate. They issue a revised contract without retained pay. If an employee in those circumstances brought a claim, as your lordship postulated, for damages arising post-termination, that would fall foul of Edwards and Chesterfield, because Edwards and Chesterfield very clearly says you cannot bring a claim for post-termination losses for breach of contract on the basis that your dismissal was in breach of an express term. Your damages are limited to the notice period, or there's a Gunton extension period if a disciplinary procedure would have taken a bit longer than the notice period.
Well, here we are at 413 on the listing of the one-day case, and you're saying the case is completely different from what has been argued all day, that it's an injunction or nothing, that there is no right to claim for wrongful dismissal. And I didn't understand Mr. Tagar Robinson to be arguing that your claim is defeated by Johnson and Unisys.
Lord, no, Lord, it is just responding, Lord, with respect, that the suggestion was made, dismissal or not, the claimants would have a claim for damages.
Yes.
And the point is very clearly, Johnson and Unisys says you can't rely on an applied term for post-termination losses. Edwards and Chesterfield says you can't rely upon an express
I mean, I haven't read Edwards and Chesterfield properly, but just looking at the head note, I'm not sure it says that at all. The head note says that damages were not recoverable for breach of contract in relation to the manner of a dismissal. Yes. Well, that's completely different from a situation where, on this hypothesis, there has been a breach of contract in dismissing and therefore subversing the right to retained pay. I'm not an employment lawyer, but one would have thought that applying ordinary contractual principles, at that point, the person says, look, you've broken your contract by doing this thing. I've got a right to damages, which will be a sort of discounted version of the future flow of money I would have got. That is mitigated by the fact it's potentially gone and accepted the re-engagement, but that won't negate the right to damages, that will just mitigate.
Well,
And so if Edwards and Chesterfield says that's wrong, where does it say it's wrong?
well, my lord, it's tab, I believe, 31, volume 3. And if we start, just very briefly, appreciate the time constraints. Speech of Lord Dyson, page 30. And at paragraph 1, this deals with the Johnson point. It's now well established that an employment contract is subject to an implied term. The employee may not, without reasonable and proper cause, conduct themselves in a manner likely to destroy or seriously damage the relationship of confidence and trust between them. And there's a reference there to Mahmood and BCCI. In Johnson and Ulysses, the claimant sought to rely on an alleged breach of this implied term, not as a foundation for a statutory claim for unfair dismissal, or as a foundation for a claim for damages unrelated to dismissal, but as a foundation for a claim at common law for damages for the manner of dismissal, like interpose their breach of contract.
But this doesn't, on the face of it, deal with the problem. Pre the employment legislation, if we'd had this situation, you could have brought your claim for breach of contract and got common law damages, and the employment legislation could not possibly have had an impact on that because it didn't exist. It can't really be postulated, can it? The enactment of employment legislation for the protection of employees took away the common law right to damages which you would have had. And this isn't talking about that. This is talking about the what I believe has come in subsequently in terms of the obligation of trust and confidence and so on. That doesn't seem to have anything to do with whether applying ordinary contractual principles, you've lost your right to damages.
Well, my lord, if one looks at the effect of Johnson and Edwards is just that if the dismissal takes effect and it is effective, your damages at common law are limited to the notice period.
That's because the notice brought the contract to the end. There can't be a proper notice in the sense of a proper notice that brings your right to retain pay to an end, full stop. We've got to a situation where you've already won on that basis. You are guaranteed to retain pay for so many years as you stay or would have stayed in that role. And you get damages for that. Unless you're saying that... I don't know what you're all saying.
Well, my lord, if one looks at paragraph 2, just very briefly, and again conscious of the time, loss arising from the unfair manner of a dismissal is not therefore recoverable as damages for breach of the implied term. Falls within what's been called the Johnson exclusion area. The principal questions that arise in these two appeals, whether the reasoning in Johnson applies to preclude recovery of damages for loss arising from the unfair manner of a dismissal and breach of an express term of the employment contract. So that's the issue.
Yes.
And then scrolling along ahead, just in the time available, paragraph 25 on page 36. Lord Dyson refers to Lord Hoffman's reasoning for not permitting a claim to proceed. Lord Hoffman also regarded the statutory background as determinative to the question of whether the new common law right should be created. He concluded at paragraph 58, for the judiciary to construct a general common law remedy for unfair circumstances attending dismissal would be to go contrary to the evident intention of Parliament that there should be such a remedy, but it should be limited in application and extent.
But Mr. Britton, I thought this was common ground. And suppose that your client's contracts were ordinary contracts of employment which didn't have the retained pay clause. Then if they are dismissed, at common law they have no remedy except the contractual notice period. In the tribunal they have the statutory remedy of unfair dismissal. But that, of course, is not your case. Your case is that they are in a very privileged position because of the terms of the retained pay clause.
My lord,
Now, supposing that the hypothesis is that you win on that, if you win on that, then it seems to me that the court declares that it would be a breach of contract for Tesco to dismiss any of the claimants for the purpose of removing their right to retain pay. Dismissal hasn't happened yet, so there are no damages payable at that stage. But it seems to me, and I don't think Mr. Degar-Robinson argued the contrary, that if the court having made a declaration, this court having upheld the declaration, but discharged the injunction, if Tesco go ahead and dismiss the claimants, then they apply for summary judgment that liability has been determined by the declaration. The only question is compensation, and the compensation would potentially loss of pay to the retirement age, but there'd be arguments about mitigation of damage and all sorts of things. But potentially that's the remedy, isn't it?
Well, my lord,
I don't think Mr. Degar-Robinson was arguing that that Johnson and Unisys or Edwards and Chesterfield or any other authority means that there can be no remedy at all.
well, my lord, I'm just addressing the judge's point, and below, both parties proceeded on the basis that if the dismissals took effect at common law, the parties would only be, the claimants would only be entitled to notice. And my lord, just very briefly, paragraph 40 of Lord Dyson, speech page 41.
Yeah.
The unfair dismissal, paragraph 40, sorry, the unfair dismissal legislation precludes a claim for damages, breach of contract in relation to the manner of a dismissal, whether the claim is formulated as a claim for a breach of an implied term or as a claim for breach of an express term. It gives an example which regulates disciplinary procedures leading to a dismissal, and then talks about Parliament's policy choices. And it's for that reason, my lord, that at paragraph 44, Lord Dyson says, I can paraphrase, he says, well, sorry, this is not to say that an employer who starts disciplinary process in breach of the express terms of the contract is not acting in breach of contract. He plainly is. If that happens, it's open to the employee to seek an injunction to stop the process and or seek an appropriate declaration. And then if you scroll down to just parallel to F, the short answer to this submission is that the injunction to prevent a threatened unfair dismissal does not cut across the statutory scheme for compensation for unfair dismissal. So my lord, that's why in our submission an injunction is necessary, because if there's just the declaration and dismissal can take effect, for those reasons I've already addressed you on, Lord Dyson considered that in an appropriate case the injunction would be erected. My lord.
All right. Well, that's the injunction. Now, Estoppel.
My lord, I'm reminded by Mr. Gilroy that paragraph 59 or 59.5 of the judgment, page 66, it does record that no submissions were made by the defendant regarding the adequacy of damages as a remedy.
Which paragraph?
Sorry, it's 59.5.
I don't have a 59.5 in the official reports. I have.
Sorry,
59.
this is core bundle, page 66. Oh, you don't have a 59.5?
No, I've got the official reported version in the ICRs, and I've turned to paragraph 59, and it's got 8 lines, and then there's a new heading, followed by paragraph 60.
All right, 60.5.
Or 60.5, the numbers changed, I think.
Numbers have changed. Lord, very briefly, and just in headline terms, because I appreciate the reply, promissory Estoppel. Lord, rather than take you to the relevant passages, if I can just give you the references and state what the principles are very briefly. And these are propositions from 34th edition of Chitty, tab 44, and paragraph 6098, as well as there being an unequivocal representation, it's established that the promise or representation can be expressed or it can be implied. So that's Chitty 6098. Secondly, the promise need not form the sole basis for the inducement, but it must contribute something to the inducement. That's paragraph 6101. As to detriment, claimants got to establish that they've altered their position in reliance.
How can we deal with this? We don't know anything about the three claimants, whether they did or didn't, do we?
Oh, Lord, that there are some certain findings in the judgment, paragraph 15, core bundle, page 44. And 4 lines down, paragraph 15, in his witness statement, each notes that he took out a mortgage obtained on the basis of an income which included retained pay, which he had no basis to believe would be withdrawn. Mr. Kumar also took out 2 additional loans. Each notes the significant impact on families' finances which the withdrawal of retained pay would cause. Each asserts that the sole reason for his agreement to transfer was the effect of retained pay. So that evidence is in there, and the judge made findings in relation to that. And we cite the references of the particular detriments in our skeleton and from the statements of Mr. Singh and Mr. Kumar.
Where does she make findings?
Sorry, paragraph 15 records the
The
evidence.
assertions, yes. And where does she say, I believe them, or I don't believe them?
Well, my lord, in fairness,
Well, she says at paragraph 51 she doesn't have to decide it.
Oh,
that's correct. She does say she doesn't have to decide it. But my lord, we've got the representations, we've got the fact that their evidence wasn't challenged in relation to it. But that's all I can say in relation to
Yes.
that. And my lord, again, just sticking with the general principles, just for noting the effect of an estoppel can have a permanent effect on the representor's rights going forward, and the reference in support of that proposition is from the speech of Lord Gough in Kanchen Junger. It's divider 9, and the relevant passage is at page 399 of that judgment. Where he says that equitable estoppel in that each requires an unequivocal representation, perhaps because each may involve a loss, permanent or temporary, of the relevant party's rights. So that is in support of the proposition that in an appropriate situation, depending upon the nature of the representation, it could permanently impact upon or restrict the representor's rights going forward. And then the only other references are to how clear and unambiguous does a representation need to be, and the appropriate guidance was given by the House of Lords in Woodhouse, the Nigerian Produce Marketing Company. That's volume 1, divider 6. And if I can just summarise the 2 passages from one from Lord Hailsham, one from Lord Salmon. Lord Hailsham, page 757 A to B. His Lordship referred to the fact that there may also be cases where the originator of a document intended it to be acted on and may in appropriate instances have to bear the consequences of any ambiguity for which he himself is responsible. So that's page 757 A to B. And then the only other passage from Woodhouse it is the speech of Lord Salmon at 771 E to F. And again, if I may paraphrase, what Lord Salmon refers to there, he contrasts, he says this: it's reasonably easy to draft a letter containing a representation, the true meaning of which is clear and unequivocal. I would classify such a letter as alpha. It's, however, quite another matter to be able to draft a letter or anything else which is not only clear and unequivocal, but is also incapable of having extracted from it some possible meaning other than its true meaning. I would classify such a letter, if it exists, as alpha plus. So the key point is, we say that the Tesco submission veer towards the alpha plus scale of the spectrum. The representations here and the combined effect of the representations are sufficiently unequivocal promises as to entitlement going forward.
Can I be clear with what the representations are? Don't take me to all of them, but what is the key representation from your point of view?
The ones that Mr. Gilroy would refer you to, reference to being guaranteed for life.
Can we just focus on that one? I think in discussion earlier, it turned out that didn't really mean guaranteed for life. There were various caveats to it. Now, if that's right, A, what does it add to your contractual entitlement? B, if it were to add anything to your contractual entitlement, why would it be sufficiently clear to be a representation or a promise that counted for these purposes?
My Lord, to be clear, perhaps I in haste to address you speedily, the Estoppel submission is only engaged if you find for Tesco in relation to the contract.
No, quite. So if we get this far, it's because we found that notwithstanding what was said at the time, contractually, the right to retained pay was not to endure forever, regardless of the circumstances, but as a minimum, it was to be caveated by reference to capability, redundancy, whatever. And actually, since on this hypothesis, we've decided that Tesco won, we've decided that the contractual right ends when the contract ends. So come back, you say, well, look, there was a representation, it was guaranteed for life, there was protection for life. But that can't mean that, can it? Because there must be various exceptions to it, which aren't stated. And then you find, well, it's just not clear enough to add anything.
Well, my Lord, absent one of those good causes for dismissal, we say the representations are engaged and are untrammeled. But in any event, the collectively agreed term does expressly state it can't be changed by mutual consent.
Well, that's the contract. If you win on if that's what the contract means, you've won.
Can we just, if you look at Mr. Webb's witness statement, supplementary bundle, tab 20, page 197, paragraph 6, he says, and Mr. Jagpreet Singh similarly, I was asked to attend a meeting, I was given, and after which I was given a letter detailing the terms of the retained pay. The letter confirmed the amount involved and guaranteed that I would receive this amount for the remainder of my Tesco life, capital T, capital L, provided I retain my role with the defendant. Have we got one of these letters?
Lord, I don't believe we did. I don't believe we did. I don't believe there's one here.
Tesco Life, capital T, capital L, looks as though it's a quotation from a term used in that letter, whatever it was.
My Lord, I don't think, from recollection, we never had it in the evidence.
Well, how can we decide if it gives rise to an estoppel if we haven't even got it? Or is that old-fashioned?
Well, my Lord, it's the representations that Mr. Gilroy referred you to, and also the.
Can I then ask, take Mr. Webb, is there any evidence that he saw and relied on those representations?
Well, my Lord, there was no challenge taken below to the fact, if I put it this way, there was no challenge taken below to the fact or objection raised on that particular.
But this isn't a question of challenging it. If he hasn't said it, there's no need to challenge it. Did he say it?
My Lord, I'm having a quick scan now. I don't believe I can identify any particular passage where he says he saw it, but he does explain why he agreed to transfer. And we do know that there was a ballot. We do know that there was literature about how they write.
Yeah, but this is estoppel by a particular person, not some abstract concept. Somebody was told something and said, right, okay, if that's the case, I'll go. But if he wasn't told something else, then that can't have been what he relied on.
Well, my Lord,
It really is fact specific.
well, my Lord, the representations that we relied upon, the joint newsletters, the Litchfield at a glance table, what we get if you were made redundant, or what you get if you transferred to a new site. It wasn't in dispute that those were communicated to the relevant workforce in the proceedings before the High Court below.
But lots of things are said. I mean, I get mail every day. I've just never even opened it. You just don't know whether they read it and acted on it, and that's the point.
Well, my Lord, I can't take it any further other than by saying.
Can you help us at all on the question I put to Mr. Gilroy about what happened between 2007 and 10?
My Lord, we haven't. But again, I don't want to give evidence. There was obviously a process of Tesco having to obtain planning consents for some of these new distribution sites, and that may have taken some time. But
Yes, all right. So.
I can't stress anything.
But as I've already pointed out, the individual terms and conditions at tab 789 are all September 2007, and the collective agreements are much later. Maybe that doesn't matter.
Lord, unless I can assist.
Right. Any questions? No, thank you very much, Mr. Brittenden.
My Lord, I'm conscious of the time.
Yes.
Does your Lordship wish to hear me on the stop?
Yes, if you can deal with it as briefly as Mr. Britton.
My Lord, this is a very curious context in which to bring an estoppel claim. In my respectful submission, the entire claim is misconceived. The usual context of an estoppel claim is where there is a pre-existing legal relationship. And in the context of the performance of that pre-existing legal relationship, someone says something to induce the other party to act to his detriment in a way which would cause him to suffer prejudice if the first party then goes back on what he said. The traditional situation is where party A says, don't worry if you breach the contract, I won't treat it as a breach or a forfeit, and I won't forfeit your lease. That's used in the Metropolitan Railway. In the context of a pre-existing lease, and then the assurance is given, the tenant relies upon the insurance by doing something that would otherwise be an event which could be relied upon as a forfeiture. The landlord changes his mind and seeks to forfeit, and the tenant says, you can't do that, you're estopped. And that's the doctrine of promissory estoppel. Pre-existing legal relationship. This is different, because this is a case where the legal relationship in relation to which the estoppel is sought to be applied is a relationship which arose as part of the same process which is alleged to give rise to the estoppel. So we're not talking about post-contractual communications which give rise to understandings or obligations in equity, which can only be given effect to because there's no consideration by means of the extraordinary doctrine of promissory estoppel, or equitable estoppel as it's also called. We're talking about a situation where it is alleged that although the contract doesn't mean what they want it to mean, what the claimants want it to mean, nevertheless, at the same time, the defendant is prevented by Estoppel from actually enforcing the terms of the contract that was made incomplete and in relation to which the communications were uttered by the time the contract was actually made.
And it doesn't matter, does it, that there was a pre-existing contract of employment relationship and there was a pre-existing right to terminate, and although it is said that these documents are the ones that give rise to permanent entitlement to retain pay, it's also said that some of those documents may have amounted to a promise that they wouldn't exercise their pre-existing right to terminate in this context. That doesn't alter your analysis, does it?
Lord, no, it reinforces it in my submission,
Okay.
because the right in relation to which I'm said to be estopped is the right to give notice of termination of the new contract. And so, in my respectful
the contract is
submission,
amended, yes.
so in my respectful submission, this entire construction falls at the first hurdle. This may be why no one thought of bringing a claim for estoppel until shortly before the hearing for the judge.
Well, I suppose, having said that, I wanted to hear from you. I've just reminded myself that you and Miss Rogers dealt with this in your original skeleton page, paragraph 37, and then in greater detail in your response skeleton. I'll just see if my lords want any further help. I think you've set out your stall, Mr. Degar Robinson.
If your lordship will indulge
Yes.
me, and I'm not sure I'm entitled to any indulgence in this case, there is a further point about clear and unequivocal representation. It's in my submissions, written submissions, but it is so important I'd like to make it clear if I may. The clear and unequivocal promise, because we are talking about a promise in this case, has to be a promise not to exercise the right of termination for the purpose. There is no basis in any of the evidence to suggest that any such promise was ever made. And that's the second hurdle in which this claim falls out. Whether one takes the evidence of the individual claimants, which refer to a letter which, as your lordships have spotted, isn't actually in evidence, and that is what they say they relied upon, not any of these collateral documents. But even if one goes to the collateral documents in my submission, there is no promise that the right of termination will not be exercised at all. None of those documents concern the right of termination. And Lord, I'll say no more about it. Lord, going backwards through my learned friend's submissions, paragraph 55 of her ladyship's judgment, I must admit to finding myself in a state of some surprise and some difficulty. Your lordship's quite right that I do accept that there is an unqualified right to damages, just as there was in the Aston case itself, the case upon which the claimants based their entire argument for an implied term. Aston was a claim for damages. The suggestion, there was an attempt to invoke Johnson and Unisys in this case, for the purposes of saying it's a reason for not implying a term, because this is dealt with by Parliament in the unfair dismissal legislation, and it would be wrong for the courts to encroach upon that territory where Parliament has very carefully balanced the rights of employers and employees in the way that it has, by implying a term into this contract so as to effectively cut across the employment legislation. Well, that's Johnson and Unisys. There was an attempt below to argue that that was a reason why a term could not be implied. Your lordship will have discerned from the skeleton arguments that argument is not renewed before your lordship. No. If the argument were right, I'd be delighted, because not only would it mean I wouldn't be liable in damages, I shouldn't be so facetious as to say I, but not only would it mean I'd not be liable, it would mean there would be no cause of action and no basis, therefore, for granting an injunction. But my lord, that really isn't how the case is put. As
I think I ascertained from your submissions earlier firstly, you're not relying on Johnson and Ulysses because it deals with a different part of the law. And secondly, that if Mr. Gilroy and Mr. Brittenden are right on the central point of construction, and that therefore a declaration was rightly granted, that it would be a breach of contract for your clients to terminate in order to get round the retain pay clauses, if they went ahead and dismissed nonetheless, the claimants would have a clear and unanswerable claim to damages for breach of contract, though the quantum of those damages would be a matter for discussion.
Lord, yes. If it did constitute a breach of contract, whatever the contractual term is, then the damages available from the High Court would be contractual damages, calculated in accordance with the normal rules.
And it would not be confined to the notice period, far from it. It was potentially a very substantial claim.
As in Aston itself.
Yes. Right.
Lord, let me just skip lightly, if I'm capable of doing anything without galumphing, through my learned friend's submissions. First of all, my learned friend sought to suggest that ground 2, which is of the appeal, which is where a submission is made that it's not necessary to imply a term, is somehow dependent on ground 1. The two, that is not right. The two grounds are entirely independent. There's a possible world in which the court accepts the judge's view as to the meaning of permanent, but nonetheless finds that for all of the reasons I've outlined to your lordships, including the fact that there's no one solution to which both parties would readily have agreed, including the fact that it could be extremely burdensome on a company such as Tesco and could impinge upon the management of its business, and all the other issues that I sought to urge upon your lordships, those are all grounds that have an independent life, which do not depend upon my succeeding on ground 1. Of course, the fact that I do succeed on ground 1, and I submit that I should, is highly material and helps me enormously on ground 2, but it's not. But ground 2 is not dependent. There was a hint in my learned friend submissions that I'm taking points that weren't taken by my predecessor below. Lord, I'm at risk of stating the obvious. Questions of construction, when I say questions of construction, I mean wider construction, including the implication of terms. That is a matter of law. And of course, evidence can be needed in order to establish matters of context. But subject to that, a question of contraction interpretation comes to your lordships, and in the normal way, your lordship decides it. It is not necessary to consider what arguments were on below, or whether the judge made an error of principle, as opposed to just construe the contract in a way that the court thinks to be wrong. I'll say no more about that. Lord, some discussion about the admissibility of the collateral documents, if I can call them that. Insofar as the judge treats those documents as evidence of subjective intent, they are inadmissible. And there are times in her judgment where she appears to do so. But in fairness to the judge, your lordship may well feel that that wasn't her intention. What she was really doing was construing documents which she regarded as being admissible as an aid to construction. And your lordship's heard my submissions on that and my toing and froing on that point, for which I apologise. I would say, however, that there is an important point of principle. They are aids at most, if they do constitute explanatory documents of the sort discussed. They are aids to construction. They are not substitutes for the contractual wording. And Lord, it must be remembered that the contractual wording was agreed between Tesco and USDAW, and then the employees had that agreement incorporated into their employment contracts. So the primary question in a case of this sort is what the reasonable persons in the position of Tesco and USDAW would have thought. And when one frames the question in that way, one does find oneself asking a question, well, why were these collateral documents produced by Tesco and by USDAW? Why would they be relevant to that question? And your lordships have asked that question of me, and I've done my best to answer.
You said a moment ago that on questions of law and construction, points can be taken in this court which were taken below. It doesn't appear to me, reading the judgment, that your predecessor took any objection to the pre-contractual documents being taken into account generally. I'm not sure what your lordship means by generally. He accepted, as I recall from the papers, he accepted that it was admissible as an aid to construction. I don't recall him making any further concession than that, but if he did, Lord, he shouldn't. We've probably covered the ground, haven't we?
I think we have, Lord. I'm trying in deference to my client's interest to make sure I haven't missed anything. I'm sorry to take your time, your lordship's time.
Could I, while you're looking through your notes, could I ask the juniors on each side to ensure that my clerk has details of the individuals to whom a draft judgment should be sent. This is anticipating a rule about to be introduced in this court, that we have to have names of counsel and of an individual instructing solicitors and one spare individual, as it were, in case the main one is away, all following the Master of the Rolls' judgment in Counsel General for Wales. Now, Mr. Gilroy, anything left?
My name is Degar Robinson, but I answer to most things, my lord. Your lordship may be rather tired by this stage. That's certainly how I feel. One submission that my learned friend made, which is in my submission quite illustrative of the lack of analysis on his side of the case. My submission is that when deciding whether or not to imply a term, whether it's necessary to imply a term, one has to be scrupulous and rigorous in analysing what the express terms say, and then scrupulous in working out what really is necessary to be in order to resolve any problems they create. One of the submissions that my learned friend made was look at the express term itself. It provides that retained pay can only be changed by mutual consent. But here's the problem. He sought to base too much weight on that phrase. And it led him to an absurd position. If you treat mutual consent as meaning you can't have retained pay taken away unless you agree, then there are almost no circumstances in which this contract could ever be terminated. It would certainly not be possible to terminate the contract of any employees for any kind of redundancy at all. So applying the logic of his own position, if mutual consent were the basis upon which one were to construe this contract as having some kind of post-termination effect, it goes too far, it creates an absurd result. And the corollary of that is that mutual consent doesn't have the effect of operating after the termination of the contract. It's talking about changes made to the contract during its life, as indeed everything else in this contract is. And the discussion about what could and could not happen, I hope your lordship found it a helpful discussion, my learned friend. I certainly did. What's interesting is that my learned friend started falling back on grounds for dismissal that are justified by Section 98 of the Employment Rights Act. He fell back on incapacity, misconduct. I'm now
redundancy, capability, redundancy.
Exactly. I'm so sorry.
Misconduct of the three he referred to.
And that, in my submission, is quite revealing. What it shows is there's a mindset which takes into account the backdrop of this contract, namely that there is employment protection provided by the statute. It's true that employment protection is not complete in the sense that any damages award, any compensation award is capped. But nonetheless, it is protection. From the point of view of the employees seeking to invoke it, it could be improved because it may not give them full compensation. But it's not only their perspective that's relevant. There's also the perspective of Tesco, and the consequences of implying that term can be very substantial for a very substantial company. And I know that often it's not an attractive thing to represent a big company when employees who their interests are involved. But the bigger the company, the bigger the losses a company can suffer as a result of being put into a difficult position. And in relation to being put in a difficult position, my learned friend objected to my reference to retained pay. In fact, there is evidence of there being concerns about retained pay in this case. And perhaps the last thing I'll do is take your lordship to the document which shows that. Lord, it's...
This is in the context of the equal pay litigation.
Yes.
Yes, well, that's fairly well known. That has twice been to this court on various points, but has not yet come to trial. Is that right?
If I could ask your lordship to go to the supplemental bundle, tab 14, page 123. This was the document, questions and answer documents that was produced in 2021 when Tesco were explaining what they were planning to do in relation to staff with retained pay. And at page 123, the second heading down, are you phasing out retained pay now because of equal pay claims? Yes. And the last sentence of that answer, it says, we are also aware some colleagues in distribution centres and stores have raised issues about pay and terms. By phasing out retained pay, this should help to address these concerns. Now, my lord, I am not relying on the existence of an equal pay claim as a reason for your deciding this case one way or the other. But what I am relying on is the possibility of equal pay claims.
But this wasn't even referred to until 2021, and even then they say it's not what we're trying to do, it may help the problem, but wouldn't we need some sort of evidence, if that's the point, that if your case is a positive case, in fact they knew there were all sorts of difficulties that could come, one of them would be equal pay, then you need something from around 2007.
In my submission, that's not right. In my submission, it can be inferred from the mere fact of the matter. In 2007, the legislation was in place which created problems where there were pay disparities. It can be inferred that a company such as Tesco would be therefore anxious to ensure that it maintained maximum freedom so as to deal with those problems as and when they arose.
Then you don't need the 2021 document.
Exactly, but I'm simply responding to my learned friend's complaint that equal pay has been conjured out of thin air, and my lord, it hasn't. And my lord, one other point I should make very quickly. It was suggested by my learned friend that the wording of paragraph 3.3 of the injunction came from the defendant. That's not
well,
fair.
I don't think we need.
It's simply not correct.
I mean, by the stage of wording, the judge has given her decision in principle, and you're tactfully negotiating about the details. I don't think we need.
I'm obliged. It's worth comparing paragraph 57 with the earlier paragraph where the final wording. Your lordship will see they're not the same. Unless I can assist your lordship any further, I can only apologise for having taken so long.
Thank you very much, Mr. Degar Robinson. My apologies to the stenographer for the fact we didn't take an afternoon break. It's been a long afternoon. Are you going to send us, or our clerks, today's transcript?
Tonight, yes.
Thank you very much. Well, thanks not only to the stenographer, but to all counsel, leading and junior, and your support teams. The case has been beautifully presented. We're grateful for your oral and written arguments. You've given us a lot to think about. We shall be in touch as soon as we can, hopefully not as long as 9 months from now. Thank you very much.